All right, I just pulled out Black's Law Dictionary right off the shelf, and I just opened it up to any place. I just opened a book up, and I'm just going to the first definition that I find that has a particular designation. And this one is on page 538 under Black's Law 8th edition. It says due diligence information, which is just a random page I opened up. But the definition is what I'm not really concerned about with. What I'm concerned about with is at the very end of the definition, it gives reference to CJS, and it says see securities regulations. And then I'm just going down to the next column, and I'm going down through to finally I see, oh, here's another one, due on demand clause. It says at the end, I'm not going to read the definition, it says at the end, CJS, section such and such. And I'm going to go down the next thing. Oh, then the very next one, due on sale clause, says CJS, mortgages. On down, next page, on down through, just scanning through it. Let's see, we got one here, procedure due process. Skipping the definition, to the end of there it says CJS, constitutional law. Next one down says standing due process, CJS, constitutional law. The point is, I can just about open up any page in Black's Law Dictionary and look through there, and I will always see reference to CJS. Look at it once and see. Check it out for yourselves. So here, Black's Law that we so highly put our definitions ability on, where does Black's Law get its authority from? CJS. And what is CJS? CJS is corpus juris secundum. So instead of us taking the statutes and codes that these fiction agencies feed us and trying to decipher those, why don't we go to the source that creates the fictions and the statutes and codes, which is CJS. We're always doing everything backwards because we're doing everything generally when we should be doing everything specially. So I've written a little paper here. The paper is titled Terminating the Guardian-Ward Relationship. It's a trust relationship. And this paper incorporates NTT as New Trust Technology Remedy as my model for achieving the age of majority, quote unquote, right out of corpus juris secundum, or terminating the guardian-ward relationship, the title of the paper, concluded from the body of law, corpus juris secundum. Concluded from the body of law that creates the statutes and codes in the fictions. Going straight to the horse's mouth. So, number one, Book 43, Corpus Juris Secundum, hereafter CJS. Section 2, 1978. Who are infants? The definition. Right out of Corpus Juris Secundum. Quote, the term infants in legal contemplation embraces any person who has not attained or arrived at the age of majority, as prescribed by law. And the word infancy means majority of non-age. According to the sense that which the terms are used, they may denote the condition of the person merely with reference to his years, or the contractual disability which entails, or his status with regard to the other powers or relations, ... However, the term infant does not necessarily imply any definite legal limit, age limit. Quote, the infant does not necessarily imply any definite age limit. Now, my comment to that is, the age of 21 is not the age of majority in general. It is the status attained by the, quote, attained years of discretion, and his conduct is intentional, unquote, where his ability to use discretion acting in power, while relationships, see above, relations, being formed as general, which are public, or special, which are private/trust relationships. Number 2, Black's Law Dictionary, 8th edition, definition of power. Power, we all want the power. Well, we got the power. Just don't understand what the power really is. Number 1, the ability to act or not act. The ability to act or not act, especially a person's capacity for acting in such a manner as to control someone else's responses. Number 3 definition, the legal right or authorization to act or not act. The legal right or authorization to act or not act. A person's or organization's ability to alter by an act of will the rights, duties, liabilities, or other legal relations. Bingo! Legal relations, either of that person or of another. 3, Book 43, CJS, Section 4, 1978, status of unborn child. Generally, and notice how these all start out generally. Generally, a child has has certain rights which the state may protect, and that the state's interest in what is, at the very least, from the moment of conception, a living being, ... So my comment is, what interest does the state have, and how does it have an interest? The state marriage relation and other state relation contracts in general, not special. State marriage relation and the other state relation contracts in general, not special. Number 4, Book 43, CJS, Section 5, 1978, protection, custody, and control. In general, a minor deprived of parental care and control is a ward of the state, over whom the state may exercise its sovereign power of guardianship. Guardianship, ... For the minor's protection and welfare. My comment is the, quote, deprived of parental care and control, unquote, happens at birth, when we abandon our children by a general deposit into the state as incompetence, instead of by special deposit as age of majority competency. Book 39, CJS, Section 3, 1976. Nature of office or relationship, or relation. Nature of office or relation. Guardian, which has been viewed broadly as a trust. As a trust. As a trust. Is designed to further the well-being of one who is incompetent to act for himself, by placing his person, property, or both in the hands of one designated as a guardian, ... Next little section there, guardianship as trust. Guardianship as trust. As a general rule, it is held that a confidential, and we know confidential from the books we've studied, that anything confidential is really a trust. It is held that a confidential relationship which arises by operation of law exists between guardian and ward. However, while guardianship has been viewed as a fiduciary position similar to that of a trustee, and it may properly be denominated a trust, quote unquote, properly be denominated a trust. Number 6, Book 39, CJS, Section 36, 1976. In general, the guardianship of an infant continues during the non-age of the ward unless it is sooner terminated by death, resignation, or removal, or by any of the other ways which are included in the discussion infra section 37 et sequita. After termination, the guardian's only authority is to tender an account and turn over the property. authority is to tender an account and turn over the property in his hands to the proper person. However, after termination of his office, the guardian may reduce to possession truces and actions standing in his own name for the purpose of closing out the trust. Closing out the trust. Quote unquote. Corpus juris secundum. And the trust, that's relationship. 7. Book 39, CJS. Section 39, 1976 again. Majority of ward. Here's what we want. Majority of ward. Where a guardian is appointed because of the infancy of the ward, the guardianship terminates when the ward attains his majority. The guardianship terminates when the ward attains his majority. ... But the guardian remains subject to the duty. Subject to the duty. If it has not been already performed, of making a final accounting and settlement. Making a final accounting and settlement with his ward. The probate court retains jurisdiction only to require a settlement of the guardian. In other words, if it is terminated and the settlement is handed over, you got no problems. But the probate court only comes in when a requirement of the guardian to settle with the ward. Only to require a settlement of the guardian continuing on to the minor and on settlement to discharge the guardian. On the ward's reaching majority, the guardian can no longer, in the absence of further authorization, represent him. Upon attaining majority, the ward becomes legal to act in his own behalf. The age of majority is determined by the domicile of the ward, and he is entitled to a decree revoking letters of guardianship issued in the latter state. So in summary, this paper is not complete, subject to be some changes in it. I'm going to add a lot more stuff, just didn't have time to complete it. Again, this paper incorporates NTT as a new trust technology remedy as my model for achieving the age of majority or terminating the guardian-ward relationship, concluded from the body of law, corpus juris secundum. Not from the statutes and codes and the forms that you get from the agencies, but the body that created, because it is the authority that created them. So we are all treated by the government/states in subject matter jurisdictions as infants. Not that we have a contractual disability of being under 21 years of age, but not being competent with age of majority. And age of majority has nothing to do with the chronological age of the clock. It has to do with our status, having the ability to act, forming our estates intentionally, with discretion, power, in determining the relation or relationships we are forming on a day-to-day, moment-by-moment basis. It's nothing more than what I've been talking about all in the past. It has been the ability to discern with discretion the difference in a relation, in that all relations are general or generally versus special or special relationships. And we have no clue what's going on. And everything is being put into deposit, either general or special. And the choice, the nature of deposits and character, two forms, which are general deposit and special deposit. The general deposit gives rise to the debtor-creditor relation by default, and everything is presumed to be a general or general deposit as debtor-creditor relation on the public side, unless an agreement to the contrary exists. And that contrary agreement would be the special deposit relation through a special deposit agreement or a special deposit instruction under NTT on the private side. The general deposit gives subject matter jurisdiction to the public side. On the public side, we are generally considered the defendant in an action brought against us. We remove ourselves from the defendant by being the defendant by withdrawing the subject matter general deposit and redepositing it on the private side by special. NTT trust deposit. Some study of equity in relation to the subject matter and to the two jurisdictions and the two forms of deposit is needed to understand the import of the meaning here. Seek out the 5/8/2010 show, and I believe it was the 5/11 that following Monday, which we reviewed. Look out for those tapes there and tie that in with this. All right, so we're back where we started when we had Floyd come on, so that's what I had to say. So let's go for the next one. It's in the line for the queue. Unknown, you're unmuted. Unknown, you're unmuted. Unknown, you're unmuted. Going once? Twice? 3 times? Okay, next one. (714). Daniel, you're unmuted.
Yes, sir. How you doing tonight, Christian?
Okay, great. How are you?
Not too bad. Not too bad. I was in the law library today checking out some stuff and came across a volume called Pomeroy's Treatise on Equity Jurisprudence. And I didn't get too far into it, but it was saying how equity and law have been merged in our modern court systems, and whereas they once were distinctly separate. And I was checking to see if you've gathered any information as far as how to switch from one to the other.
Well, you go into the same court, which they say they've merged it. Yeah, they have merged it because you go to one court now, and you
Right.
either access through that one court either the equity side or the at-law side.
But what if you got a judge that's simply not qualified to be an equitable chancery judge?
Teaching by cleaning his clock.
That sounds like fun.
Show him how equity works under trust.
Right. And also under definition, you brought up the word infant. If you look up man in Black's Law Dictionary, the third definition says that a man is a vassal to a lord, basically.
Yeah, I've read that. Yep.
So,
Little time, never left it.
So when you stand up there and say, I'm the flesh and blood man, then the joke's still on you.
You're incompetent. You're incompetent. You have no idea what's going on in court today. You just made a general statement. And you took your private stuff held in private and you commingled it by bringing it into the public, and you yourself breached your trust. They know you're incompetent. Today, we have public versus private. How did that come about? That came about by trust. Trust. How do you form a trust? You deposit segregated res. Aren't they segregating public from private by keeping the two separate? That's segregation. That's trust. Today, public and private are segregated. That's trust. Now, when you take and try to bring your private stuff into the public, you have commingled and breached your own trust. Or if you try to take the public and put it into the private, you'll breach the trust again. You got to keep it private. Everything's got to stay in its own realm. Can't be taken back and forth. You've got to know how to do that. That's what we're on these calls for. It's general, which is public, versus special, which is private. There's the two realms. Private is equity. At law is public. Anything else?
Nope, that was it.
Well, imagine that book is if you had a chance to go through it.
Yeah, I'm going to head back there tomorrow. I just ran out of time.
What was the publication date on it?
Publication date it was the 4th edition, which I believe put it in somewhere in the 1940s. It was 5 volumes, written by John Norton Pomeroy.
Mm-hmm. Well, it might not be so contaminated if it was, shortly after 1933.
Well, I think his first edition was published in 1898. So.
There you go. That'd be the one I want to get.
Right. Is American jurisprudence very similar to Corpus Juris Secundum?
Yeah, it is.
Because I've been thumbing back and forth, and that they're both written very similarly, and they seem to have similar information as far as their, what their books cover.
Right. I think the corpus is just the body of law in general, and then the American jurisprudence leads more towards the specific case sites and in support of the case law precedents.
Mm-hmm. Okay. Well, I'll be looking through those books on a regular basis.
Yeah, especially corpus. Yeah, especially Corpus Juris Secundum, because Black's Law goes through that. Airplane, it might. I'll bet you nobody's really noticed that. But if they just go through Black's Law, just thumb through it, see how many references on one page are just to CJS.
I've got the 9th edition in front of me. I don't see any CJS.
It doesn't take too many flips before you're going to find a bunch of them.
Right. Nope, that's all I had, sir. Thank you.
Okay, great. Thank you. Okay, next caller. Tammy, you're up. Anybody else have a call? Get in the queue line, press *6 and *1. Tammy, you're there.
Yeah, can you hear me?
Yeah, here we go. How you doing?
Good. I had a great day today. I located a 170-volume hard book set of Corpus Juris Secundum law books, copyrighted in 1980 with supplements dated in 2000. The whole set I'm picking up tomorrow. Forget this, $75. I just had to share because I'm so damn excited.
Oh, wow, you got a bargain.
I almost hyperventilated when... Yeah. But anyways, so that was my excitement for the day. I was like, woohoo. Just goes to show how damn dumb attorneys are. They don't know what their stuff is worth.
Well, that's okay. Don't tell them.
No, I'm not going to. No. I would have went down there today, but it was late in the day, and I was like, whew, okay. Yeah, cool.
So how did you get your set?
Huh?
So how did you get your set?
Oh, I have my ways. I'll share after I get them in hand.
All right.
I was so excited. But anyways, a lot of reasons.
Just everybody in their locals, probably send out some requests to some of the local attorney firms and see whether or not they got some surplus sets they like to get rid of.
Yeah.
So go down to your local library and inquire about the old books that they've got.
Right. Yeah, it was a law firm having to close their doors and be out of there by Friday, and I get the books. So I'm like, sweet. But anyways, whew, so that was exciting. And I missed the first Guardian Ed Ward, and I was reading out of Amger on it, but it's not as inclusive as far as the Corpus Juris. It's more, the Amger's more pleadings and forms, and which is good, So now I'll have both sides of it, which is way cool. But a thought came to mind, question-wise. Now, when a person wants to, say, straighten up their bank account situation, and I know I had my daughter sign her bank account as agent and all that, and took copies of all that. But now if she wanted to go back, and it happens to be like a, credit union type bank, could one just do a UCC1 claiming that bank account as trust and reclaiming a Donna 3 as a special deposit and thereby more or less securing a bank account that way. That's my thought.
Yeah, we're using the moving titles platform, but since we've come up with this new additional step, it would be a UCC1 and a UCC3 and another UCC3. The first UCC1 would be to claim it, and then the first UCC3 would be to withdraw it from the general deposit back to you.
Right, and then the second UCC3 would be to put it back in as a special deposit.
Right, right.
Okay.
Right. And then also correspondingly with the counties to make the double records.
Exactly, exactly. Now, could one also do that as well with one's place of employment? In her case, presently, no federal taxes are being withheld. Nothing's being taken out. But to change that whole record, couldn't some kind of process be done on that as well?
Yeah, I would suppose so, but maybe that was not causing her any problems, all right?
That's just it. That's kind
Yeah.
of stepping on the fine line whereby...
Well, I would say that until we know more knowledge on maybe how to handle something a little bigger like that,
Yeah.
We've got it all down before we start doing some big stuff, Something like the bank to change a deposit from general to special, that should be, I don't think I see a problem there, but maybe with something with the IRS and the employment agency and stuff, that's kind of hitting home that if you made a mistake, you might be out of a job.
Right, and I don't want to jeopardize that for her.
Yeah.
I don't want to hog up the question thing because I know we were supposed to only ask one, so I got more, but, if there's other people that...
Well, go ahead, give another one. You're on a good line. Usually you're so low we can't hardly hear you, but we can hear
okay.
good.
My outside voice going on. Okay, I got a friend that is involved in, okay, bottom line, to cut it short, I guess, my question would be, could she treat an IRS summons of her bank account as the trust res and use that as a res on a UCC 1 and 3? I believe she can, and I also believe that she could simply use the birth certificates as, quote, trust res and claim them and transfer them for her situation.
Yes, to both of those.
That's what I told her as well, that I felt either or to claim it, and, of course, the duplicate copies. Now,
yeah, so on a summons, I would probably want to put, an endorsement on there and make it into a special deposit, and that would be the formation of the trust.
Okay.
Or I could go back to what the original signatures were they formed this trust, and that would be, way back when she filed her first 1040, say.
Okay, do a non-pro-tunc type thing.
Yeah.
Okay. Very cool. Yeah. I know I got another question, but it's not coming to me right now. It will. I'll get back on.
Okay.
I'll sign off for now. All right.
Thank you. Okay, next caller. Floyd, you got another question?
Oh, yeah. I was wondering, I've been looking in Black's Law, and I can't find the CJSs either. And I'm looking in 4 and 9 to see if I can find them. Where do they show up?
Right at the end of the definitions before it goes to the next.
I know that I get cases like criminal law 51, homicide 818 for emotional insanity.
But it's not listed on every one of them now. You got to go through and see,
Okay. Okay. Well, I'll have to go through and see if I can find it. I've been looking for it and haven't seen it yet. My question.
If you get the abridged editions, you're probably not going to have it in there.
No, these are hardcover. They're the big guys. 9 and 4, and I do have a 5th abridged, but the 4th and the 9th are not abridged. I'll look through them.
Well, my 8th edition is chock full of them.
Huh.
I didn't look at the other one, but
I would have thought. Well, let's see. I would have thought that the 4th would have had plenty of them in it too, because that's that's an old one.
Yeah, I see my paperback 7th doesn't have any in it. But my 8th edition has got tons of them.
Huh. Well, I know that the 4th edition has a lot of law, a lot of case citing. Yeah. Well. Well, I'll have to look into that a little bit more. Anyway. I was going to ask. I do have a couple questions. I've got a credit company that I got to take care of, and I really don't want to pull a UCC1 and a UCC3 for that, because they should be easier to take care of just in debtor-creditor relationship. And one of the things that I was going to say is, if I just ask them for their power of attorney that they have from the company that they're representing, I know they don't have that. That would put a stop to that, wouldn't it?
Yeah, but here's what I would probably do. I'd probably go to the principal that's trying to think they're the principal on this whole thing and collect. I would revoke their power of attorney, and then I would give all this secondary agents trying to collect, give them notice that they don't have any power at all.
So who do I go to the primary? You mean
the first one that you got the debtor-creditor contract with?
Okay.
Terminate that general deposit, and then I would do a revocation of the power of attorneys with them. And then every time somebody tries to collect for them, then I would send that notice to them that the power of attorney has been revoked.
I see. Okay. All right. On my court case, where I went to prison, the courts actually put me in prison fraudulently because they didn't show both sides of the contract. In other words, they didn't reveal both sides of the contract, and they didn't reveal that they actually had me in an indiscretionary trust, that they were using me as collateral.
Yeah, you didn't do that. That's the problem.
Well, is that you can't come back on them for fraud then, huh?
They're not claiming a trust. You are. You're the only one who can.
Okay.
See, what you did is you formed the debtor-creditor relationship. You did this. You did the general deposit.
Yeah.
It was your choice. You created that mess yourself, and now you're trying to come in. Well, trust. You didn't express it to be a trust, so it can't be a trust until you express it to be one.
Okay. Well, so I can't go back and pull my general deposit back out and
yeah, you can.
Huh?
Yeah, you can.
I can?
Yes. Uh-huh.
Oh, okay. And that's because a trust can be claimed at any time, right?
Right. Nobody needs to know or operate in a trust. Needs to know that it's being operated or formed.
So I would just take my court case and the court and put them on a UCC1, do a UCC3, and then a UCC3, and then write up a trust, do an indenture, write out an indenture on my intent.
Right. Then what?
Okay. And then what?
Then what?
Well, then I would notice them as to what I was doing, and because they would be the trustee.
Okay. What's your purpose?
My purpose is to clear my name, and also to get back anything that was attached to my name, as far as what do you call it?
So far, what are you going to do next?
Okay, let me see here. You mean as far as after I've done my my paperwork, my UCC1 and UCC3 and UCC.
Okay. Now, what did that do?
Okay, what that did is by my claiming it on the UCC1, that's now mine, and that puts it into my ownership, and then I transfer it. Then I pull out my res, or my what do you call it? Anything that is attached to my name, I pull that out of general deposit. And
there you go. General deposit. You're going to withdraw the general deposit,
and then I'm going to place it back, the trust res back into specific deposit or special deposit, and then I'm going to write a indenture. Or what my intent and purpose is. And my intent and purpose is to clear my name, and to take anything. What do you call that? Golly, I can't. I'm not a lot. I got to look for. I have to find my notes here.
You're doing good so far.
Well, I'm trying to find the wording as to what to say, because that's what I'll put on there. The wording, the same wording that I used for what I've been using for my telephone.
Okay, so what you did so far was you claimed it, you withdrew the general deposit, and you redeposited it back now as a special deposit.
Right.
And you got intent and stuff all with there. Now what are you going to do after that?
Then I'm going to notice the court of what I'm doing, and I'm not quite sure about who would be the trustee. Probably the judge that prosecuted me. I don't know.
Now, why would you be in court? Why would you be in court?
Well, I wouldn't necessarily have to be in court, but all I'm saying is that, well,
what's the next basic step you're going to be taking?
Well, I'd have to get into equity.
Why do you want to go into equity?
Because equity cuts through all of the everything that it goes right to the heart of the purpose. I don't know how to say it, but
okay.
It goes,
But why you find it necessary to go into equity?
Because that's where I get my remedy.
All right. Why do you need a remedy? You're missing a step.
Okay. Well,
If I need a remedy, something else prior had to happen that I need a remedy for. What would that be?
Oh, I'd have to lose on the statutory side.
Okay, that could be, but I need a cause of action. And what would that cause of action be that I'm going to go seek a remedy for?
Pardon me?
Think trust.
Oh, in trust? My cause of action in trust?
Think trust.
Okay, my cause of action.
You got to have something that you're going to seek a remedy based on. What is it you're basing your need of remedy for?
Well, I was I was going to say to clear my name to get out of their jurisdiction.
Okay, that's colorably, but what are you going to need privately to do that with? I need a breach of trust. How are you going to get them in a breach of trust? Don't you have a remedy based on a breach of trust? The cause of action of breach of trust?
Well, they'd have to come back and disagree with me, wouldn't they?
No, not necessarily. I mean, they probably will, but okay, I need a breach of trust, right?
Well, wouldn't I be? Well, I keep looking at fraud, but I suppose you can't
that's
really.
Colorable. That's colorable, but privately. To seek a remedy, I need to have a breach of trust, right?
Yeah.
All right. How did I get the breach of trust?
How did I get the trust?
How did I get the breach of trust? What breached?
I don't know. I don't know.
You jumped to enforcement for your remedy, but you didn't specify that you had a breach enforcement, and you haven't included the step to get the breach.
Okay, well, I guess I don't know how to do that then. I can't.
So to get them in a breach, you got to make a demand for the special deposit back.
Oh. Okay.
Or to carry out duties that they didn't do according to the special deposit. That would be a breach.
Okay, but I'd have to make that special deposit before I could make that demand.
Yes, right. But that's what you were saying. Up to that point, you explained to me all up to going to do the step 1 and the 3 and the 3, and you got it up to the point you got to trust. You had the intent and purpose and the parties, everything spelled out, and then you're jumping into court.
Oh.
You're jumping in on enforcement, but you don't have the next steps to complete the process.
Okay. So then I would write a letter of demand to them.
After I got the deposit in there, right?
Yeah, and I would want them to I'd want them to restore my name and give back any
all the purpose is going to be completed within a specific time, or else they're going to be in breach.
Okay, and I would tell them that anything that they have made off of my name as far as money, I don't know how to state that, but that's what I would be saying. Any attachments would be refunded to me.
Yeah, but now we've got to learn how to use the right proper verbiage according to trust.
Yeah, right. Okay, so instead of attachment,
that's the problem with most of us out there. We don't have enough knowledge yet to create the verbiage, and that's going to be our downfall.
Well,
we're out creating documents that we have total general deposit verbiage in there. We got debtor-creditor stuff up the yin-yang, and believe me, I can tell it in a minute.
Yeah. Okay, well, as long as I know the steps that I have to take, I guess I could probably, with some thought, come up with what I need to say.
Yeah.
I mean, it's not like I have to do this thing, in 3 minutes or anything like that.
So let's pick up. So you need a breach, and when they're in a breach, then what's the next thing I'm going to give them?
Once they're in a breach, then I have to follow. with letting. Well, I have to let them know that they're in a breach.
Yeah, there you go. Notice of breach.
Okay.
If they're in a breach, you give them notice. And then what do you do after a notice of breach?
Let's see, notice.
I'm going to give them an opportunity to cure.
Oh, okay.
Length of time.
Right. Okay. Opportunity to cure. And then if they don't cure,
now I can go in for enforcement.
Then I have to file a. Then I'd have to file a claim against them. Is that what you would do?
Yeah, and I could just do a show cause hearing as to why they should not be sanctioned and held in contempt for breach of trust.
Oh, okay.
And I could go for a mandatory injunction.
Okay.
But we have to think on each step along the way. Have I done due process? Have I noticed everybody of what's going on? Have I breached the trust myself? Have, think about the details in between the steps. Is it all there? Is it all complete? Put the model together first, and then from the model you can start working on the detailed verbiage for what you're trying to accomplish. Because now you know exactly what you're trying to do. And then the words will come next.
Yeah. Okay. So then, after the mandatory injunction, that would be the last step then. Or would there...
I would say so. Yeah.
Okay. Okay. Well, let me think about this a little bit, and then as far as the company that they got the credit card or the credit company coming after me wanting because I told the credit company send me the bill because what I was gonna do is send it back to them with a letter or something. But I'd have to. But what it is it's Vonage is the company that they were supposed to give me a 30-day free trial, and when I got the equipment, I couldn't use it, so I sent it back, and I was still within the 30-day period, and they said they never received the equipment. And they charged me $70, and I didn't pay it. I told them that I wasn't going to pay it because and they said, well, they needed the tracking number, and I didn't have a tracking number. So anyway, it escalated to a $200 deal, and so that's where I'm at with them right now. I just told them I was never going to pay it.
Well, I'd be creating evidence of a trust and putting all the stuff they're sending you in trust and start billing them for the trust stuff.
Well, I suppose I could make them. I could put them in a contract and tell them to.
Not a contract. Put them in a trust. Put them in a trust.
Oh, okay. All righty.
You see, the problem with this general arena, or the public in general, is that anything we do in the public or in general is all debtor-creditor. And debtor-creditor gives rise to that debt situation, and the debt situation, that's really a sin. I hate to say it, folks, that's a sin. I don't want to do debt anymore. I don't want to operate in the public in doing debt. So I can't do secured party creditor, except for value, because all these things do, I can't do negotiable instruments. They have to be non-negotiable, because non-negotiable is private. Anything that's negotiable instruments is all public. It's all debt. And debt to a Christian is sin. And the sin that we're placing upon all of us as brothers is insurmountable. Somewhere along the line, we've got to pay the piper. So we need to get out of the debt mode. Don't do debt anymore. And we get out of debt by using NTT, unused special deposits. And that extinguishes the debt. And we thought all along that we were doing set-offs and discharges and offsets, and we weren't. That can't. It's impossible.
Yeah. Okay. All righty.
So I don't want to really use the debt realm any longer.
Yeah.
I want to use trust, because trust will match the asset title with the debt, and it'll merge the two and terminate them.
Yeah. Okay. All righty. Well, I'll do that then.
Extinguishment of debt as payment on the public side. Extinguishment of debt would be private, but payment is on the public side.
Yeah.
Both simultaneously. One is the mirror image of the other.
Right. Okay, so then, I'm going to work on this court thing and see what I come up with. And in the meantime, I got a couple other things that I need to take care of too. So
you're a busy guy. You know that?
Yeah. Yeah. It looks like I try not to get busy, but then all of a sudden it just comes in on me, you know. Oh well. Well, it's the way to learn, you know. I mean, what can I say? Yeah. Okay.
Thanks for the questions.
Yeah. Well, thank you, Christian. Okay, I guess that's all I need to know right for tonight.
Okay, we've got some more. Come on back in. Anybody got a question? Press *6, *1 to get in a queue line and raise your hand. Okay, next caller. Area code 702, you're up.
Yeah, Christian, this is Joe from Southern Nevada.
Hi, Joe.
How you doing?
All right.
I wanted to share something with you that happened to me. I had signed a contract with a cable company, and they quoted me a price, and then when I gave them access to my account, they took out more than they were supposed to, and so I canceled the contract, or I told them I wasn't going to use their service. But they claimed that since I had signed this contract with them, I owed them some money. And so anyway, they started calling me. And one day they called, and I asked them, I asked them if the call was recorded. And they said, yes, it was. And I says, well, I'm expressing the trust. And they says, well, when are you going to make a payment? And I told them I already made the payment. And they go, you have? When did you make the payment? And I says, when I signed the note, I made the payment. And then they said, what note? And I says, well, you know, for that you have to talk to an attorney. I'm not able to give you legal advice, but when I signed the note, I made the payment. And, you know, I haven't heard from them in like 3 days. I don't think they'll ever call back again. And this also happened, I also owed a hospital some money, quite a bit of money. And I pulled the same stunt with them, and I haven't heard nothing from them. So, and I made sure that the call was recorded, and I told them I'm expressing the trust, and that I made the payment when I signed the note, and I haven't heard nothing from them again.
Yeah, I wouldn't say that this was a same stunt. I wouldn't call it a stunt.
Well,
this is real. So,
right.
Yeah.
I just thought I'd share that with you.
That's good. That's great. Yeah. So NTT works.
That it does.
Anything else?
No, that's. I just wanted to share that with you.
Okay, great.
Thank you.
Thank you very much. Okay, next caller. Area code 415, you're up.
Christian?
Yeah.
Yeah, it's Chris.
Hey, Chris.
Hey, you know the case that I was telling you about, the traffic case of where we made the judge, the trustee, and the attorney for the defense? I found the answer for that, and I wanted to read it to you really quick. This is in the How to Recuse a Judge sets of laws. When the judge had entered a plea for the defendant, such as a not guilty plea, he actually became the attorney for that person's defense. And it's a little bit of what you were talking about tonight, but this number 2 of this document, the judge serves as a lawyer in a proceeding or in any other proceedings involving the same issue. He or she serves as a lawyer for any party in the present proceedings or gave advice to any party in the present proceedings upon the matter involved in the action or proceedings. So by doing or entering a plea for someone, they're no longer neutral, that they have actually stepped out of their box and became a biased or a prejudiced party by entering a plea. Therefore, he ends up becoming the trustee and or the attorney for the defense of the proper outcome or the meaningful outcome for that person. He becomes trustee.
Right.
And anyway, I wanted to tell you that this document was given to me today by one of my other researchers, and this is really great. This would be a good document for everybody. The P's and Q's of how a judge can be recused and or taken out and dismissed off of a case. And this goes along with the canons and the code of ethics that a judge has to abide by. But I'm going to go ahead and post this out to everybody as soon as I clean it up and highlight it. But I just wanted to bring that to your attention, that that's the reason why that judge had to be extremely nice, is because at that point of sending that letter off to him, he was absolutely obligated to the hilt to make sure that that case was either dismissed or it was settled in the favor of the defendant.
Mm-hmm.
Anywho, that's it for right now.
Okay, thanks.
Uh-huh.
Okay, next caller. Anybody have any questions? Press star 6 and star 1 to get in the queue. Anybody with a question? We've got an empty board again. Anybody with a question? Press star 6, star 1. Anybody else?
Hello.
Yes, go ahead.
Oh, how you doing, Christian? This is Albert.
Hey, Al. How are you doing?
Okay. Hey, man, I was listening to an old audio. I felt like I had to go back to the basics just to catch up, and I came across the corpus juris secundum. You came out and stated something about Book 10, page 166, and you gave the definition of an issuer and a piece of paper. And I was just wondering, do you have any law, anything executive on it that would have some teeth besides just that?
Well, if you get a hold of the book that I quoted from, all in the footnotes, it lists case after case after case after case. So,
yeah, that's a hard book to get a hold of.
Well, the law library's got it.
Okay. Well, another question I had, and it's kind of rudimentary, but you were talking to this gentleman, and he had brought up some questions for you, but he really didn't let you answer them. He kind of answered them himself, but you had something a little more detailed in the answer, and it had to do with the very issue of putting in the non-UCC and you were going to state the verbiage that goes on it, and somehow that didn't happen. So I was wondering, can you give me on the verbiage for a UCC1 and a 3 transfer, what kind of verbiage would go, just for the record?
Yeah, I do remember that. Actually, he quoted it himself, so...
It's just that when he started talking, I just didn't take it serious, because I wanted you to say it. But what I understand is that you put in the mark in there on the non-filing, the UCC non-filing, and in Block 4, you can put in something to the effect that you formed a trust, and this is, notice only, and that's for the 1. But when we came to the part of the 3, that one I didn't get very, very easily.
Okay. I'm seeing if I can find it here.
Okay. But I do like that corpus juris definition, man. That's just about as powerful as you can get. And meaning to what you're looking at, for every one of us that have signed documents of some sort or the other, us being the signer is the same as being the issuer, which is the same as being the owner, which is the same as demanding the doggone paperback, and I guess you're just a few steps away from just deleting the doggone thing.
Yes, that's right. But under a general deposit, what we've done is we've transferred the property to them without comp to them. And then, not knowing it, we also transferred the title to them, and they look at it as, since we transferred title to them, they own it. But just for the facts we just stated, they don't own it, and we can ask for it back.
Well, that just about says it all, man. When you read that thing, it just hit me like a brick. All we need is to be able to believe what we read here. And when I asked you about executive decisions on it, I meant is there a, besides case law, something lawful, something like code section? I know it all deals with debtor creditor, but the point is...
Here's the thing, really. It comes down to the relationship that we were forming, and we didn't know anything about relationships, and that's one of the key things from the majority attainment. So when we understand the type of relationships that we got, the choice that we can make at that point, that it could have been either a general deposit by default or it could have been a special deposit by choice. Now, when we come to that realization, now you've got majority of age. That gives you the whole understanding, the grasp of the public versus private scenario.
Well, that's the model. Brilliant. That was brilliant of you, Kristen.
So this is the verbiage that we used on the UCC1. So this is actual and constructive public notice by grantor as owner and holder of all right, title, and interest with the non-negotiable instrument claim number RA such and such a number US, along with all attachments, proceeds therefrom are fully claimed and the records are being held in the private. That's it. And the next paragraph is, if there's any information regarding this that needs to be gleaned, please contact the grantor at the address below.
Anything special on the 3 transfer?
Okay, now the 3 is basically the same thing. It says that this is actual and constructive notice by grantor as owner and holder of all right, title, and interest with the non-negotiable instrument claim number RA such and such -US, along with all attachments, proceeds therefrom are hereby fully transferred. The transfer records are being held in the private. Next paragraph. If there is any information regarding this that needs to be gleaned, please contact the grantor at the address below. So basically it's the same verbiage, except one's the claiming and the other one's the transfer.
There was something else that that you also spoke about. I had taken a note. That way I wouldn't sound so stupid on the phone. You talked about the it had to do with change the like your signature. You do a C1 on it, get it back, and then you take it from them. See, I got a little confused in that little ping pong there that you were doing, but it sounded good. You understand what I'm talking about?
Yeah, well, since we come out with this, we've done an additional step in between, which was another UCC3, which was the withdrawal first before we made the special deposit on the second UCC3. Okay. So we do a withdrawal, withdrawing it from them after we did a 1 claiming it that was ours. So we withdrew it from them on the first 3 and then redeposited back to them on a second 3 as a special deposit. So we changed the nature of the deposit from special to, or from general to special.
Do you think that stating the definition of the corpus juris, do you think stating it anywhere along the process is counterproductive, or is it productive for us? When we're requesting the contract back, you know?
I think we have a tendency to include things in there so that they know that we know what we're doing, and it's really not necessary because they don't really have to know.
Okay. And a little question. Like I said, this I was listening to some old tapes, and what I understood with you speaking was how to be cryptic in expressing the trust without them knowing about it.
Correct. Yeah. Mm-hmm.
Do you have specific verbiage on that?
Yes, I do. Uh-huh.
Great, man.
It's just like the example I gave, you know, I want my pen back. Actually, that was expression of a trust.
Okay. But being cryptic, in other words, where they don't know that you are expressing a trust. Was there anything special on that?
Yeah, I'm looking here.
Okay.
So you could say, I give you my whatever, my name, for example, in confidence with reliance to be returned in the future along with the proceeds therefrom with my interest. Nothing in there was mentioned about a trust. Nothing, no trust terms at all. But that was a trust declaration.
I just asked these questions for the good of the call. You know, I know there's a lot of rookies like me on it, and just going over this stuff that you went through in the beginning, I think it's just brilliant. You know, this thing you brought up on corpus, it didn't hit me the first time, Chris, because I remember that call. But this second time I heard it, oh my gosh, that's a good one, man, real good. And thank you, Christian, and thanks, guys, and I hope AIB lets me back on their website so I can get more files run. Thanks a lot.
Okay, great.
I guess there's nobody there.
Okay, next caller. Anybody? Thanks, Alberto.
Hello.
Pete, you're up. Hey, Pete.
Great. Yep. Oh, yeah. I want to talk about I want to ask you about the bookkeeping side and the accounting side when we come to do a special deposit.
Well, I can't talk about that now because I ate all the beans up.
Oh.
We had ham and beans the other day, and there's no more beans to count anymore.
But then, we've still got some interest there, haven't we?
Depends what you want, which you call interest, yeah.
Pecuniary, monetary.
You know, all on the public side, they classify interest as being some kind of value because they all want to see it as being some kind of figure that they can, under commerce, use GAAP principles and tax it. But really, interest has no value on the private side. It's just a thing. But yeah, you're right. On the public side, we do have an interest of value that was generated from our signature, and all that is ours.
Exactly, yeah. So, have you looked into how to navigate it?
How to navigate? How do you mean? How to reclaim it all?
Yeah.
Colorably, you'd have to do it in such a way that it would make sense to them on their public realm, but actually I would be recovering it through equity and trust with probably a mandamus or a mandatory injunction.
Right. So you wouldn't be expecting the institution to sort of honour that, or do you think that to be a chance that they would?
Probably if I had to go to the injunction mode, they probably wouldn't be honoring it because the injunction is the enforcement. That is the device we're going to have to use for enforcement.
But do you really think that you would have to go to such an extreme when it's already sort of in law, if you like, that they would pay interest on special deposit?
Well, I think that we have to enforce this probably a couple times, like we have to come up with a Jericho first. And once we make an example, just like God made an example out of Jericho, then the rest of the battles are easy.
Yeah, yeah. So they're going to push us to see what we know, and then we come back in with a mandatory injunction, and then they're going to go, oh shit, pardon my French. Yeah. Cool.
That would be holding their feet to the fire and letting them get blisters.
Oh, what a shame.
Yeah. Until they cry uncle.
Because I think that, you know, all the deposits are in the bookkeeping side anyway as equity, because, you know, that's the column that it's in the bookkeeping. And that creates the liability. Now, then it gets jumped over to the accountant side, and that's the side that they offer to us. Is that because we're never claiming it as special deposit, then we can't reach into that bookkeeping side?
Yeah, we set it up to be that way to start out with, which was the general deposit, and we need to revoke that and come back in and set it up the way we want it then. And then we've reached that age of majority that, you know, we should have the funds because we get to determine in the power, which was the ability to choose either relationship, either to act or to not act. And if we don't act, then it's general. If we do act, it's special.
So how about earlier on when we've been talking about giving away a clean signature, would we still have to go back in and redo the signature, or are we happy with the signature that we've given and we're just going to claim it as special deposit?
Well, in the formation of the trust, I might not have to sign by grantor, although it would come down to whether or not I could defend my intent, because that's what it really comes down to. And nobody can change my intent except myself. So I really don't need a qualified signature to form a trust, although I'd suggest that most people do, at least some kind of ellipsis, at least. But the important thing is to create the records that they can see that it was your intent, because you want to manifest your intent. And the records that you form that they can see, that is the manifestation of your intent.
Yeah.
It doesn't make a difference when the trust res was transferred, or what mode or method did you use to form the trust. It's just that you manifest it by the record. And that's the only thing they can see, a manifested record. They can't see what you are thinking or what you intent other than what is written down on a record.
Yeah. Cool.
So how was the call earlier? Any...
Oh, superb. How did you think of the English guy studies?
Yeah, they were up on some of the stuff, yeah. There's always room for improvement, though.
Sure, yeah.
We got this debtor-creditor mentality in our thinking. And now we got to segregate it and get it into trust. Separate the two sides, public and private.
Which does seem to become more simple.
Yeah, the more that you play around with it, the more you think about it, the more you run it through your mind, the more you put it down on paper, the more you discuss it, the more you know. And I don't even need to do any of it, you know.
Yeah.
All you have to do is just exercise it. You know, when you got a muscle, you exercise it and it builds up. Well, your mind is a muscle also.
Yep.
The more you use it, the better, easier it becomes.
It was nice to hear that guy saying that he's expressed orally. That was something I know that you said you wanted to do, or you were aiming for. And there's a guy pops up and says he's done it now.
Yeah.
Fantastic.
We need all this fancy paperwork and stuff. We could come in and express the trust orally, yeah. I don't even think we have to go into the courts. We could do it a DIB hearing before. We are the courts. We are equity. I just go into court to find out whether or not they've formed the trust and extinguished the debt. Or not form the trust, recognize the trust and extinguish the debt. Let's put it that way.
Yeah.
So I'd put all the documentation in prior to that, and then walk into the court and say, has this been extinguished, the debt, according to the trust indenture? If not, we got a problem here because you guys are in breach. Okay, anything else?
No, fantastic, as usual. Thanks very much.
All right, thank you. Next caller, Jacob, I guess you're unmuted.
Yeah, hi, how you doing?
If you'd like to ask a question, please press 1 to add yourself to the queue. Your request has been received.
It was,
Hi. What's up tonight? What's your question?
well, it appears that most people are under the thinking that the origin of them being brought into the world is through the so-called birth canal, and they have been taught that it's the mother's signature that's the almighty blue ink wet signature that brings them into being a registered whatever on their birth certificate and what have you. And the topic tonight, which is guardian and ward, is a really interesting topic. And the fact that you pointed out where blacks is, following suit with the CJS work. And for a long time, I've been working out of blacks, but I've always comported it to Hebrew law as opposed to the CJS. And so I just wanted to bring out maybe how Hebrew law would look at this from the father's perspective as opposed to the way they're construing the origin of the mother being the more important party. So this is from the Mishnah, and it's considered the biblical or nursing father, is unknown to the Mishnah, and a guardian is called apotropos, which is they get from the Greek. The ward is simply yatom, and it means orphan, but more importantly, it means fatherless. And so the Mishnah says that a guardian appointed by the father, which seems to include any other transmitter of inheritance, must swear at the end of his trust that he has kept back nothing. One appointed by the court need not swear. Abba Saul says just the contrary in the Talmud. But a man who has minor children or whose wife is pregnant should, when nearing death, name a guardian, which he may do by word of mouth. He may appoint a minor, a woman, or a bondman, or according to later views, he may order his estate to be turned over to his minor heirs direct. When the father fails to act, the court, as father of the fatherless, should appoint a guardian who must be a free man and of full age. He should be of good repute, trustworthy, able to assert the rights of his wards and plead their cause, and versed in worldly affairs. If a kinsman, he cannot take over real estate. When the court finds that the guardian is wasting the estate of the wards, and when in the case of a guardian appointed by the court, he falls under suspicion by living beyond his own means, and he should be removed. And so I thought, here where the guardian is appointed by the father, and this is the only time he's ever told to swear. And the court need not to swear, okay? So, in this accounting, it says that only an appointee of the court has to clear himself on oath, the solemn oath. But when the ward, on coming of age, makes a distinct claim of what is due him, every guardian must clear himself by oath. A guardian is not required to render to the ward or to the court detailed accounts, but religion, the sacred one, for the father of the fatherless who rides the heavens. The guardian is not liable for anything stolen or lost, but is liable for negligence or fraud. And I guess what stands out is that it's very similar, to a trustee, where you could...
Well, from what she just said, that stuck out in my mind, jumped out was the fact that the father really abandoned the child and then appointed that allowed the court to come in and step in. With the claim, when the ward made the claim, now it's exactly about out of corpus that said that was the age of majority, because now he knew he had a right to choose. He had the right to choose a different relationship.
Yeah, on coming of age.
Yes, the age of majority.
Mm-hmm.
So both of these kind of comport together.
Yeah, I thought they did very well, and that's why I wanted to. I kind of see. I'm kind of trying to see how the guardian ward relationship I would like to maybe see if you could kind of explain it as a trust. You know, because right.
I didn't get a chance to write in more of the stuff because I wanted to point that out even more yet, because everything in corpus was spelling it out as it's a trust. No way around it. It's a trust, although they don't recognize it to be a trust until you express it to be a trust. It's just a general until you express it and change it. If we don't express it, it's by default general, debtor creditor.
So, but this violation by fraud, or you know, then it goes. You know, when you try to comport the breach of trust to you know, to the enforcement of the guardian wardship trust relationship, it kind of, you know, it's kind of like if you're trying to think through a strategy, a model, as you mentioned earlier, you know, you said, you know, you got to put your model together first, right?
Right.
And so it seems like the biggest push over some time has been like going in from a, you know, a breach of trust. But here in the guardian-ward relationship, you know, it says that the guardian is not liable for anything stolen or lost, but he is liable for negligence or fraud.
Yes, that's what corpus says also.
Okay. So in demanding for the trustee to fulfill the fiduciary relationship, especially when they're the same as the beneficiary as one, when you're getting ready to terminate the trust, and they fail, there is a breach of trust and fiduciary relationship. But is there not a liability for negligence and fraud?
Yes, there is, but the duty was set up according to, say, statutes and codes, and they're running the show the way they want to for the betterment of the ward. And that it's really, they've formed the statutes and codes, which are the laws, and the law is the tutor that is taking care of you under debtor creditor.
Okay. So,
but when you come to a point in age of majority that now you realize that you got a relationship choice and you had something you could choose that was different, now that terminates the guardian-ward relationship right there. And then you need to ask for a final settlement or final accounting and settlement. And that guardian is supposed to give it to you. Otherwise, he's in breach because he needs to close out the trust and reduce it all down to possession, your possession. Now, there's the verbiage right out of Corpus Juris Secundum. Anybody out there that wants the verbiage, you need to be reading these books.
But wouldn't it
You won't be asked the question, what's the verbiage for that? It's in here.
Okay,
You'll be able to write your own indentures.
So if we reversed it, though, if you completely reversed that whole story, and now the court, which would be today, would be over the fatherless child, when the court has a breach of meeting the I guess the fatherless child, I guess in this appears to me to be the ward of the court.
Yeah, but anything the courts decide is good for the child. Anything that the courts decide is good for the child. They got total carte blanche say so.
Yeah, but if they breach their duty or their
yeah, but how do you know what the duty is when anything goes? The duty is they're talking about is that when the kid reaches majority, he can tell the guardian it's terminated. Give me my stuff.
Yeah, but
now they can't say anything to him any longer because now he's reached age of majority and the authority and duty has ended. The court is no longer the guardian or their appointee, the guardian. The state guardian, whoever's the guardian is done, period. It's that simple. We're doing it all backwards. We're making it harder than it is.
Well,
it's easier.
I can give you like a daily example of some, the way I am. But last week, as an example, I had to do a renewal for a passport for one of my children. So I actually drew up my own passport renewal document, and I actually wrote it into a grantor trust. And I submitted it to 2 different countries to pass snuff last week. And the first country, they were shocked because I have my own family seal that's in 24 karat gold that I always stamp into my own documents that I make. And originally, this one situation, I had delivered the child myself, made up her own birth record, and I put it under my own law form from the beginning. And so that child wouldn't ever be a ward of the court because I never gave them any authority or permission, or never entered into their paperwork and had my own family paperwork to do that.
Right.
You follow me?
Uh-huh.
So this would be, I would want to go back to this example of being the father, and this statement about a guardian appointed by the father must swear, but the appointed by the court need not swear, okay? And so can swear, I guess what I'm trying to get at is in this guardian-ward relationship, in a father-child relationship, everybody's so used to using paperwork that's given to them, and everybody has to get used to learning how to make up their own paperwork in order to express the trust, correct?
Right.
So do we have to, I guess everybody's geared to believing that they have to swear. In other words, they have to sign paperwork.
Well, what's the reason for them to swear? Because they're coming into that public venue and they want that private venue to swear. Because they're in their public venue, they don't have to swear. They're within their own venue.
And what precludes them from having to swear being in their own venue?
There's no law in their venue that says that they have to. In fact, there's laws saying that they don't have to.
So it's their law. It's actually just basically their law form, so
right.
They don't have to do it.
Yeah, like if I go over to France, I got to listen to what French law is. France is like the U.S.
Mm-hmm.
Their laws don't go in their realm. But see, you're under a debtor-creditor relationship, under a guardian ward, and you've abandoned your children, most of us, and we're incompetent fathers, and the state has stepped in as the father.
I know, Christian, that a lot of people are really hurting right now because of what you just said. And so I won't talk about it now, but maybe sometime in the future we might, think about how we can, develop that trust, how to withdraw that, you know, where those people have stepped into where they've given the, you know, the agencies that be, you know, control over their children, and there's so many people I've seen lose their children recently. You know, from Child Protective Services or whatever.
General deposits that they've made. That's all. That's what the whole show tonight is really about. The termination of the guardian-ward relationship by reversing the general deposit and putting it in the special deposit.
So for those people that were in trouble, would they go to the Department of Health Services and then withdraw their general deposit?
Yes. Yes.
And then they would just, their special deposit, by the way, would just be to, unfortunately, I think they have to change the name of the child because they have to put a special deposit in where they put a new name for the child, and in the same place, they actually do a search for the name of the new child, and then they get a receipt, a trust receipt, that name doesn't exist in that county any longer.
Possibly, but you don't really have to change the name. You can just change the jurisdiction. I don't change the nature or character of the name. I can just change the jurisdiction. Pull it out of public and put it into private.
Basically a 133 move?
Yeah.
Okay, thank you, Kristen, very much.
All right, thanks, Jacob. Okay, next caller. Anonymous, I guess you're unmuted.
Hey, Kristen, you unmuted me?
Hey, Albert, go ahead.
I didn't know I had my hand up. But, hey, on the special deposits, when we redo the UCC ones by taking back and transferring, say, our name out of their hands, and what is it? Would it be the next document that we would state, or at least in our own case, making? I didn't even come. Sorry.
The UCC what again?
I'm sorry, Kristen. That didn't even come out right. When we have made general deposits, I mean, the majority of us have, and we have to take that general deposit and change it. But you know, earlier you brought out that UCC1, the verbiage, and then the UCC3 transfer. But you also brought out something about taking your name out of their hands and then doing their name as a trustee, right?
Tonight, you mean? I said it tonight?
Yeah, I thought you did.
I don't remember.
Well, it's okay. You know, I didn't know what else to ask. I just want to get these, you know, special deposits right. We're not as brilliant as you, Kristen.
Well, I'm still learning, so.
Well, you're shooting over my head. And the reason I'm asking you this is because a couple of weeks ago I had these chicks here that are having problems, you know, and that I heard one of them finally called you up and asked a question that she needs to ask, and you directed her to Carlos, I believe, and I think she's working on that. But the other one with this special deposit stuff, you know, doggone, I couldn't answer her on what I asked you earlier because it was all rudimentary and I thought I knew. And, you know, she beamed me on the head with a doggone popcorn, you know. You know, I popped popcorn and the doggone corn stuck in the back of my head. And, you know, I just thought, well, I don't want to go through that again. You know, they get mad. They're hot, Christian. You know, what can I say? I opened up my mouth, and next thing I know, got a bunch of them here. But anyway, you know, I'm hoping that they overcome their shyness and you know, call you up and learn these little things for themselves. But you know what? I'll try not to put you into that position with them as much as possible. But thanks, Christian, and I'm still listening on.
Okay.
I don't know what else to say. I hope you got somebody that can ask a more intelligent question.
Well, there are no dumb questions. The dumb questions are the ones you don't ask.
That's a good one. Well,
Okay, next caller. Unknown, you're up.
Hi, Christian.
Hey.
All right. I almost forgot what I was going to ask you. I guess that's all right.
I
I guess
got
you
an
got
arms question, so.
you got a new setup going here. This is kind of cool. My question, I guess to start, actually, I want to back up a little bit and just to put a little context in.
If you'd like to remove yourself from the queue, please press 1. Otherwise, press 2.
And you basically came up with the idea that we've got to do the withdrawal before we do the special deposit. What was it again that got you, that made you say, hey, this is the step we're missing, just so I can kind of feel the rationale there again?
About scanning through about 160 books.
Oh, I figure. But was there something in the language that, because originally we were thinking, some kind of letter of communication along the lines of something of a declaration of intent, because I really caught on to that, and I like the logic and simplicity of it. But I think there was something in the terminology and the definition that a withdrawal is necessary. We can do the special deposit on something that was already deposited as a general deposit. Is that basically what you're discovered through all that reading? Are you there?
Yes. Through reading all these books and stuff, it becomes very apparent from reading it all that it jumps out at you that it's a distinction between the two realms, and most of it is general. And you got to watch out for the special things in there, because that's what you pay attention to. But it was just through more and more reinforcement of the same material, and it just jumps out. It just jumps out. But, I'd like to say one thing, I have a Heavenly Father, and I pray. And the things that I ask for, He grants.
I believe it.
I pray the prayer of Solomon, and believe me, that works. So
you have to explain that to me sometime, but I absolutely, I believe in the principle.
Want to know the reason how this all comes about? That is the reason.
Okay. Well, and I think it's the due diligence part. I think they go together. One feeds the other. God helps those who help themselves. But you're putting a lot of work into it, but still there's a lot of guidance. So I can totally see where you're coming from. But okay, let's see. I got to focus on another question here while I'm in this new setup. I understand the general idea, and it does make sense. We don't necessarily, on the public side, I guess I'm kind of re-going over stuff here. On the public side, as far as the colorful account on the debtor's creditor colorful side, it doesn't necessarily mean that we have to close that account, because we were talking about the titles, and I'm pretty sure that we got that clarified, that we're just basically asking to withdraw the general deposit of the title, and then we are making the claim first, and then doing the withdrawal of the general deposit on that particular title, and then using the second UCC3 to do another assignment, which would be the purpose of transfer, another form of assignment, which is a form of transfer to do that special deposit. And this would be our proof and record of to satisfy any request to prove the trust, right?
Yeah, right. That's also merging titles, same thing.
And we'd be merging titles at the same time. Okay, that's cool. Now, on the colorful side, which is kind of stuff that Floyd's working on, he's very particular. I want to keep it kind of loose as I move up to this thing before I get particular. But in general, what do you see in general that we should be doing for correspondence with these folks? How much of this can we mention? I was thinking back to the time last year when I did my routine, and I get up and I said, you know, I'm the trustee and grantor in fact with special interest in the name. Do you understand that? Technically, I wasn't specifically. I mean, the judge did tell me to shut up on the second time. I said that on the second visit in the criminal court, which means that it really worked quite effectively. And I think he was, you know, just trying to save everybody some kind of a lot of confusion. I think he knew I wasn't going to budge. Technically, though, I guess even by just saying that, because I'm thinking about what the other guy said actually, and maybe you can make some commentary on possible interpretations. I know it's speculating because he didn't give a lot of information, but he just said basically I called these people up and I expressed the trust. I don't think he added any more to that and said to signature, maybe he sent something back in, signed. And I said that, but I guess by saying I'm trustee and grantor, I haven't really specifically touched on the trust itself. I just said I'm the trustee and grantor. Now, does that make sense to you, or what are your comments on that, maybe?
Well, they actually have a live body testifying that there is a trust, and what that party claims, if he's claiming he's grantor, he's the one who formed the trust, and it's his testimony that's live parole testimony in court.
Okay, so I was...
That is the actual proof of the trust right there.
Oh, okay, so yeah, so I was, and I wasn't necessarily making specific reference to it. I was just saying I am the grantor for it. So I was cutting a fine line, but I was pretty much, I was okay for the most part.
Yeah, because they didn't challenge it.
Yeah, and they didn't challenge it, and it definitely threw them off. They were thinking debtor creditor. So, okay. Now, just sort of getting back then, now actually here's another question that just sort of come to mind. Actually, I'm looking at this document, the NTT, and making the payment. Have we changed anything, especially in light of that conversation with Gamba when he was saying he had a different way? I don't know if he shared that with anybody or followed through on any of that. But is it basically still the same instruction on that that document that you put out about the private non-negotiable special deposit order? Is that still going, or has there been any updates to that?
There's two versions. Which one do you have? The one that says special deposit on it?
Yeah, the one I got, it says entity making a payment, merging titles under trust, front side. It's got a little picture, looks kind of like a check, and it says private non-negotiable special deposit order.
Yeah, okay, that's the more modern one. Okay, then the lower one, does it say pay to on the endorsement side on the back?
On the back it says, without recourse, pay to, full colon, blank.
The pay to, I don't like pay to anymore. We should be putting special deposit for, and then spelling out a specific purpose there, and then leave a blank line to sign in blank.
Yeah, I guess that makes sense. Take out the pay to, and then what did you say to put in? Sorry.
Special deposit to, and then it's the, you know, to whoever with the purpose, and then leave a blank line for in blank endorsement. So that's kind of like a special deposit indenture order right there.
Interesting. So, yeah, special deposit to blank for the purpose of yada yada. Another blank, I guess. And then you're still leaving by trustee, your signature, for strawman, SS number, all that?
Right.
Okay, now on the front then, it says
we're cleaning up all our debtor-creditor terminology and taking it out and putting it in trust on the other side. We're segregating it.
Absolutely, absolutely. It makes perfect sense, actually, now that you pointed out. Special deposit to as opposed to pay to. Right? That makes sense. How about on the front side where it said pay to the order, payee is the beneficiary? How would you look at that then? Would that be...
Probably have to clean that up too.
So this instrument, it does say on it, private non-negotiable special deposit order. Now what's a little confusing to me right now is that you said special deposit to, like the part on the back, without recourse, special deposit to.
It's in blank. It's in blank. So it's a bearer instrument that whoever was holding it should take and fulfill the instructions on that they should pay it or extinguish the debt for the obligation of the beneficiary.
Okay, so we can create this and pass it to someone else then for their benefit, so they can ledger their accounts essentially.
Yeah, whoever's holding it, they can ledger it with that because they're holding it. It's a bearer instrument.
Okay. Now, then on the front, just to get the understanding, you were saying you had here pay to the order, payee is the beneficiary. Now, payee would be the party that we're trying to get to settle the.
The court was saying that the payee line was the one you made out the note to, but that's colorable. The payee could be the beneficiary on the colorable public side, but on the private side, which is non-negotiable, then the payee is going to be, whoever the beneficiary really is, I guess. But that could be on the front of the check or front of the instrument there would be the pay to line would be like could possibly be pay to whoever in trust for the benefit of so and so.
Okay, so that we're still sticking with the payee or the company as the beneficiary.
Yeah, it's like you got to give it to whoever it is going to pay the debt, and that may be the bank, say, to pay the mortgage loan or whatever, say. But that special deposit in trust to ABC Bank for the purpose of extinguishing the debt obligation against account number such and such or beneficiary so and so.
So okay, so you're saying you could make the bank the beneficiary with instructions to say forward this to or do the transaction on.
Actually, when I say to ABC Bank in trust, that makes them trustee.
Yeah. As I just put that there. ABC Bank in trust. Yeah. Now you can kind of leave the pay to ABC Bank in trust. That works.
Yeah. In fact, I'll probably take out the pay to. I put special deposit to ABC Bank in trust for purpose of extinguishment of debts and liabilities against whoever the beneficiary is or the account.
So you can reference the account right there. So who would be, when you give this to them blank, who's going on the back, doing the special deposit to as well on the back then for the purpose of, that's almost the same thing again. It's a reiteration of what's on the front essentially?
Yeah.
Okay. That makes sense. Okay, so that's kind of cool. Now, on the colorful side, we're just basically sending some kind of a notice to that party, letting them know that we'll be looking after the accounts and to expect some kind of payment via the bank that we're dealing with, say, for example? Maybe even just also letting them know that we will be operating in trust. Can we mention that?
You'd have to redraft that old general deposit to a trust deposit first. And you could do it with that instrument, put an instruction along with it if you wanted to.
Yeah, ultimately, I hope to use the existing remittance voucher that's on the statement.
Yeah, that probably would serve as notice to the party that we're dealing with. But now, if I had, you mentioned another public notice. I don't know why I would need to have another public notice. We got a court action or something we're trying to go in and express the trust in?
No, just trying to keep it real simple. Just the typical bill statement you get in the mail, and just the basic. I've got the idea on the UCC side what has to be done. Would they need copies of that for proof, or that's just something I hold in case I have to go to court, for example?
Yeah, you'd have to give them due process for the give them the copies.
I mean, I'm sure. Like, what will happen is they'll send some kind of a letter saying, what's going on, and in that letter, actually, I could privately communicate to them actually a lot of detailed information, couldn't I?
Yeah, but it might be, who you're doing business with. Are you doing business with the underlings under there? They don't know what the heck you're doing.
Oh no. Well, I would make all my correspondence to the CEO.
Yeah, there you go.
They always send letters back saying address it to me, and I just ignore it and I send it straight back to the CEO. It's straight enough, and you can always find that. If I can reference the CFO, even put the names of those parties on the letter. It's actually just good for reference. You get all those specific company information in at hand. But yeah, no, I would do that so we can still pick up a lot of pieces of stuff that I've done in the past. It's really the understanding, and of course this is a whole completely different understanding. I like it. So basically, I'm trying to keep it as simple as possible. I'd rather do a lot of simple, maybe like a very basic letter, very few words, very well thought out, just saying this is what I'm doing because I got that'll be calling me pretty soon, and I just sort of want to be ready for it. And then I think if push comes to shove, I mean, just like the other guy on the phone there, what do you think was going on with that fella? He's just like, okay, I'm here, I'm expressing the trust. I think if they ask any questions, I mean, that might just be the response. Do you not understand? I'm expressing a trust here.
Right.
Yeah, okay. So that was kind of my questions. And I'm still trying to keep up with you on these books here. I did finally get my book order. Finally got the guts to go and pick them up myself. They didn't give me a hard time. I think they're starting to get easy on me. I took my passport and I wrote, without prejudice, all rights reserved. Just wrote it on there. I don't know if that made a difference or not.
Where are you going to pick up your books at?
I go to Buffalo.
Oh, Buffalo. Okay.
I thought I was going to save a whole lot of time, and it added an extra 4 weeks because the guy who was supposed to pick it up, his van broke down, and he took him out of commission. And the other guy whose mailbox it was, he didn't want to. He's so busy, he never had a chance to go down. So I said, oh, man. So I had to go down, but I have to renew I had to do it before my license is and my passport's all coming up in June, so I just got down there. But it was great because I got like 7 books. I got a couple of Uniform Commercial Code. I got an old Bogarts from 1939, case law and trust, and UCC in a nutshell, and Black's Law. I got the Commercial Banker's Handbook for $15, 1989. That was a steal. Nobody bid on it. So getting closer. I'm just catching up on you, Christian. Now I just got to get your corpus juris, and I'll see if these UCCs are good enough. Unless I still need one with you're saying with commentary.
Did you hear that Tammy got her set for $75?
Corpus Juris for $75 bucks. How many was in it?
167 volumes.
Wow. So not a bad deal. So there's a few good deals out there then.
Yeah.
That's not bad. That's not bad at all. Good for her. What year was it?
I think she said, what was it, 2000 or something like, or 98 or something.
What do you think about the older series, like stuff from the 50s and 60s?
Yeah, anything. Anything.
Yeah, I think. Yeah, okay, because I think a lot of good books were written in the 60s. I just find that they were much more open back then. 50s, 60s, late 50s, early 60s stuff is really good to read. Okay, well, anyhow, that's my questions. Thanks for clarifying that. I'll think of some more questions. I'll let somebody else come in. Thanks, Christian.
Okay.
Unmuted.
Go ahead.
Hello, Christian. This is Terry.
Yes. Go ahead, Terry.
I have a question. Maybe you can clarify something for us. Floyd's been bringing up stuff about the UCC filings. And from what I gather in those discussions, it's possible for us, and correct me if I'm wrong, but it's possible for us to file a single UCC1 and a single UCC3 claiming back or transferring back our name or signature, and then that would cover all account holders that we would deal with from then on out. But we would have to fill out another UCC3 transferring that back to them individually. Is that correct?
Yeah.
So that would very much simplify the whole process of the UCC filings. Now, in that, we would, of course, do one notice for the claim and one for the transfer in the county. And then give, I think you'd mentioned, we would issue our own certified copies of the originals that we retain to each of the account holders, correct?
Right.
Okay. So then we can send off a letter giving them specific instructions and orders to do what we want them to do, along with those documents to prove that there is a trust form and they should acknowledge them and take notice.
Right.
Okay, great. Just wanted to clarify that with you. Appreciate it.
Muted. Unmuted.
I liken it to that Star Wars movie where they had the Death Star, and the thing looked like it was a ball, but yet it was completely functional. But it was looking like it missing pieces. And I think all this stuff is really just like looking at the leaves of a tree. You think that's a solid ball of leaves. No, it isn't. It's just a leaf facing. But inside, just under the foliage, is the bare branches leading to the master trunk. But yet we think we are seeing, one big massive green ball, and it's not. It's mostly empty space. And we're missing some things because we can't see it. And it's kind of like looking at a rubber ball with chunks out of the other side, but you can only see the side that looks complete, and you don't see the other side is not complete. And it's like, okay, if you're looking at a flat piece of paper with a circle there, and you got another smaller circle right in the center, and that smaller circle, that's the NTG Trust. And then with spokes in a wheel going out to the outside, and all these spokes are listed, all the different kind of agency relationships that are all different, like the leaves of the tree. But that's the thing that's confusing us all. But they all form and point to the center. And you really can't see it on a three-dimensional thing because the center's hidden. It's hidden by their agency leaves. But they go down into the center, and the center is where the trust is. It's hidden. That's what's hiding this. It's all these agencies that we got. We got grantor ward. We got this agency, that agency, this relationship, that relationship. But yet they're all comes down to just two. It's either general, which is all these different agencies under debtor-creditor, and that compares to the other side, private, which is special. And private, there's only one. It's easy. It's just trust agency, just trust relationship. Public side's very confusing, but it can be reduced down too if you look past the leaves.
Do you think all these CEOs, CFOs that we're sending all of this documentation to that supposedly know how to operate in trust, are they doing this process themselves?
I don't know. I would think so.
Or is there any way to verify that they are or not?
Well, I know there's an awfully big side on the back office banking. It's far greater, like the iceberg under the water that you don't see, the 9/10 under the water.
Right. That's where all the big profits are made.
Yeah, most of the public is generally dumbed down and doesn't realize what's going on. They're all working in general.
Worker bees.
Yeah. Where there's more specifics, that's where all the special stuff is, and that's where all the special knowledge, the special training, the special this, the special that. And when we're talking about special, Black's Law. Black's Law, 8th edition. I wanted to read a definition earlier, and I forgot about that. It reminded me. Special statute. Special statute. It says it's a law that applies only to specific individuals as opposed to everyone. There's also termed private statute or special act. And it says see cases, statutes. And it says see corpus juris secundum statutes, sections 148 through 149 and 154 through 155 and 159 and 162 through 201. Then it says in the little paragraph from Lon L. Fuller, Anatomy of the Law in 1968, quote, it is ancient wisdom tracing back to at least as far as the Roman taboo against the privilegedom that laws ought to be general. They ought to be addressed not to particular persons, but to persons generally or to classes of persons, say all householders, or, wow. Accordingly, a number of American states have inserted in their constitution prohibitions against private or special statutes, and these have endless difficulties, quote unquote. Special statutes. Look that one up.
I know a lot of people have some ambivalence about getting involved in any of this because of the potential for the powers that be coming after them because they may be revealing stuff. And this incident recently with Jerry Kane and his son kind of brings that to my mind.
True.
And of course, we've heard that their main interest is in those, or they're focusing on those who are simply teaching this, not necessarily all the individuals that are attempting to implement it. I guess the question I have is, do you see that we are doing anything that would threaten overturning their apple cart to the point that they would focus their attention on those who are starting to implement trust?
I can't answer that one. That's on an individual basis, how the dice is going to be rolled, so to speak. But, anytime the slave tries to get off the plantation, they caught the slave and they, whatever they did to him. Yeah.
But it seems like in all the readings that you're doing that refer to having knowledge or becoming sentient, that once you meet the qualifications, then they ought to kind of give you a pass to come on in.
I would think so. I would think so.
Because you're not trying to disrupt their system.
Right.
And it seems like too many out there in the so-called sovereign debtor-creditor arena have the intention of tearing it down and building it up again.
Yeah, I'm not for so much doing that, but maybe on an individual basis.
Yeah. Okay, I appreciate your insights, Christian, your diligent study, and all the information you've been giving us.
Okay, thanks, Terry. Next caller.
Muted.
Tammy, I guess you're up.
Oh, hey, hi. Can you hear me?
Yes, go ahead, Tammy.
Oh, good, good. I have a question about, again, my friend, and in regards to...
You may now ask your question.
The question is this.
Muted.
Got a website online, and she gets a notary to attest to the fact that these, like, say, maybe NOI and SOI are recorded simultaneously in the county via just a simple notice online, and the notary attests to it. Would that suffice for the second notice? She's trying to save funds, type thing. And I thought, damn, that's a good idea, because she does have a website where she can put them out there in the public and then have the notary do an attestation that he witnessed that he's seen him in the county and that he is further attesting to that fact. So I thought that was pretty cool on her behalf, thinking on that, because she's pretty savvy with setting up websites and doing that kind of thing.
I think you'd have to go to the evidence rules and find out whether or not that would be one of the exceptions.
Yeah, I kind of mentioned that too. I said you got to look at the federal rules of evidence and see. I know the notaries are exceptions to the hearsay rule. And I said, but that's pretty cool. Okay, so a little further research as far as federal rules of evidence type thing.
Yeah. I don't know if that makes it public enough that that's going to qualify as a public filing or recording. I'm not sure. You'd have to check that out.
Right. Makes sense. Okay. One other question. When a while back, this dates back all the way to January, where we learned about the whole prescription issue where, they'll never acknowledge the debt because that would end their prescription, and
right.
And they won't stop it. So if you do a reverse on that and you say, hey, I acknowledge the debt, and then say to them, but what's the amount? I want to get this done. What's the amount? Does that also work in reverse? In other words, stopping their prescription when you say, I'm acknowledging the debt, but just tell me what it is? Or is that basically going back to requesting an acknowledgement of the debt? That's just a thought. That was something that came up in my head.
I don't think they ever will acknowledge the debt. That's a problem.
Yeah.
They never have.
Right, exactly.
That's probably the reason why they never have.
Right. Well, I don't know. That's more setting up for, I guess, for debtor creditor. And the more that I think about it, you're just better off if you get something that you can put on a 1 and a 3, go that route versus saying, I acknowledge the debt, but give me the amount. Yeah, okay.
Yeah, why don't I just ask for, give me the debt title or whatever you say it is, and I'll just put an asset title with it to match it, and let's just merge the two and terminate it.
Exactly. There you go. Yeah. Why battle in debtor creditor when obviously it doesn't work? Okay. Good.
Yeah, give me all the debt. I'll extinguish it for you.
There you go. Yeah.
I know how to handle the debt.
Very good. All right. I'm back out again.
Okay. Thanks, Tammy.
Thank you.
Next caller, Floyd. You're up.
Yes. what is that CJS that you were reading out of about the Lord reaches the majority?
I believe that was book 39. Let's see. Yes, book 39, 1976.
1976. Okay, and that. Okay. Chris, I think it was Chris, brought up the fact that the judge put in a plea for him or somebody, and that's exactly what the magistrate did for me. He put in a plea of not guilty, and I asked him, I said, "Are you representing me?" And he said, "No, I'm not representing you." And I said, "Well, then how can you put a plea in for me?" "Well, I did it because you wouldn't." That's what he said. And in my documents, it shows that he put a plea in for me. And that's according to, I don't know which, it's something number 4. It's in the I can't think of what you call them.
Did you do anything to rebut it? Did you do anything to rebut it?
No, I didn't know anything. I didn't know anything at the time.
Anybody who doesn't rebut it with something then actually waives it, and they agree to it.
Yeah, well, I did question it. I didn't rebut it, but I did question it. Anyway,
but you should have said, "Objection, Your Honor," or you can't act as my attorney. I don't grant it.
Yeah, knowing what I know now, I would have handled a whole lot of things differently. But so anyway, I'll just go in and claim it on the UCC 1, UCC 3. Terry brought up that point about not pulling my name back out, being that I already have on this one case, or on this one case, yeah. Because I do have a UCC 3 stating that I pulled my name back out of general deposit. But I guess it wouldn't hurt to do it again, would it? Specifically for this case.
Have you already done a 3 already?
Yeah, I did a 3. Remember when I had to make the wording so that it was previous to the UCC 3?
That's for the Sprint thing, the bill?
Yeah, that was for the Sprint thing.
Right. And what do you want to do now?
Well, I have my name in trust now, so because I pulled it out of general deposit, and now as long as I don't put it back in general deposit again, I won't have to pull it out again.
Right.
Unless, yeah, okay. So I just have to do a UCC 1 and a UCC 3 then. And
you did a 1, you did a 3, and then you did another 3, right?
Yes, I did.
Okay, that's all you need to do.
Okay, because I can always refer to the notice.
Yep.
Yeah. Okay. Very good. I guess that should do it then. So I've got UCC 1, UCC 3, indenture, notice of breach, opportunity to cure, show cause hearing, and mandatory injunction.
Opportunity to cure, did you have that one in there?
What was that one?
The opportunity to cure, did you have that one in there?
Yes, that was after notice of breach.
Okay, right.
An opportunity to cure, and then show cause hearing, and then mandatory injunction.
Yep.
Okay. Okay, Christian. Well, that's all I have for tonight then. Thank you.
Okay. Next caller, Chris, you're up.
Yeah, I found a set of the Corpus Juris Secundum on the web. It's a complete set. It's a 1987 set, and they're asking for offers. And I'm going to post that over there on NTT for everybody to whoever wants it. It looks like it's located in Rapid City, and I don't know what SD means. Is that South Dakota?
South Dakota, right.
Yeah. So I'll just go ahead and post that. And I did clean up that document on how to dismiss a judge or recuse a judge. And that set of document has something to do with the partial impartiality, prejudice, and a few other things. So that's a good document. I'm going to post it over at NTT for everybody.
Okay. All right.
So, and then I think that's it for me right now.
Okay, thanks, Chris. That's it. All right, well, it's 10 till 1, so we'll call it a night. So thank you all for joining us, and we'll see you tomorrow night at 10 p.m. Night, everyone.